Robinson, and I'm a UK qualified competition lawyer, and a lot of my work is in the aviation industry. In this video, I want to talk about how EU competition law has been applied in the aviation sector, and by the end of this talk, I want you to understand some of the particular features of the aviation industry. So we're going to look at how EU competition law questions have arisen in the sector and how they have been dealt with. I want you to bear in mind two things. Firstly, the industry is constantly changing, and this means that airline and airport business models have had to evolve to meet changing circumstances. It also means that this talk will be up to date only on the date of its recording. As I speak, the European Commission is finalising its decision in Ryanair's third attempt to acquire Aer Lingus, and this is believed to be a prohibition decision. It will be interesting to compare this decision when published with its first Ryanair Aer Lingus prohibition decision in 2007. Now, the aviation industry is also subject to competition law developments that occur outside the sector, whether as regards restrictive agreements, abuse of dominance, merger control, or state aid. I want to structure my discussion in three parts. In part one, I will discuss the industrial and regulatory background to the aviation industry, and the 2 points I want you to take from this section are firstly, that the aviation business has high capital costs and low margins, and this fact has important consequences for how competition law applies. Secondly, aviation is a global industry, parts of which operate in a liberalised regulatory framework, whilst other parts operate in a more closely regulated framework. The same airlines may participate in economic activities under both types of framework. In part two, I will survey the particular competition law questions that have arisen in the aviation industry, taking in turn restrictive agreements, abuse of dominance, merger control, and finally a brief discussion on state aid. It is important to remember that competition law questions affect the relationship not just between two or more airlines, but also between airlines and airports and other aviation service providers. Finally, in part three, I will draw some conclusions. So first of all, I want to talk about some of the economic features of the aviation sector. You often hear that the aviation industry has made a cumulative loss over its century of existence. Whether or not that is true, it does indicate something of the perceived fragility of the industry. Another line that is often quoted is that the easiest way to make $1 million is to have $1 billion, then start an airline. The industry has very high capital costs. Aeroplanes don't come cheap. Airports are complex and sophisticated businesses. The industry is heavily regulated for safety and security, fuel costs have been high for some years now, and airlines are increasingly facing the cost of environmental law designed to address noise and atmospheric pollution, as well as the advance of passenger rights legislation. As the industry has been liberalised in some parts of the world, including in the EU and the USA, airlines have faced far greater competition. There have been two consequences of this. The low-cost carrier has emerged to challenge the network or flag carrier, and many flag carriers have struggled to survive. If we apply a standard methodology to understanding the profit constraints within the industry, we see the following. First of all, competition within the market. In many parts of the industry, there is intense competition between carriers at an individual route level and increasingly between the competing networks of the global aviation alliances. Secondly, barriers to entry. As regulatory barriers to entry have fallen, so new airlines have emerged and existing airlines have expanded their operations. In addition, the growth of secondary airports has expanded possibilities for new market entry by carriers and increased competition with primary airports. Thirdly, the possibility of substituting alternative products or services. In some parts of Europe, there are possibilities for substituting high-speed rail services for short-haul air services. Fourthly, the bargaining power of suppliers. As air travel within Europe has grown, some primary airports are suffering increasing congestion, pushing up the cost of using these airports to the carriers. And fifthly, the bargaining power of consumers. Increasing competition has allowed consumers to shop around for the best price. Some argue that the barriers to entry as an airline are low. That may be so, but the barriers to long-term, successful and profitable entry across a range of routes, I would say, are high. There's a line on the Boeing website that goes, "Starting an airline is tough, running a profitable airline is tougher." I think there are three consequences of this. First, in mature aviation markets such as the EU, large-scale new market entry at the moment is quite rare. Instead, consolidation or cooperation amongst airlines is seen as desirable to reduce costs and improve profitability. And finally, airlines consider a variety of ways to improve profitability, which may give rise to questions under competition law. Let me now turn to the regulatory framework, and specifically those aspects of regulation that are relevant to the application of competition law. The core piece of legislation in the EU governing the aviation industry is Regulation number 1008 of 2008 on the common rules for the operation of air services in the community. This regulation updates and consolidates the three packages of aviation liberalisation legislation that were introduced between 1987 and 1992. Together, these created a single market for all EU carriers and a single EU-wide operating licence. EU air carriers must be owned as to more than 50% and effectively controlled by EU member states and/or nationals of those member states, directly or indirectly. EU air carriers are entitled to operate intra-community air services. EU member states may not require any permit or authorisation for operating intra-community air services by a community air carrier. By abolishing member state regulation over access to routes within the EU, the liberalisation legislation gave rise to real competition within air services and led to the birth in Europe of the low-cost carrier, bringing new routes and lower fares for consumers. The EU has actively promoted the development of a common aviation area between the EU and its near neighbours. There are two important points about this. Firstly, the Open Skies judgments of the Court of Justice of the EU confirmed the jurisdiction of the EU to negotiate air services agreements on a community-wide basis with third countries. The concept of a community carrier is more widely accepted. And secondly, air services agreements have become less restrictive, which means in practice increasing competition on services between the EU and third countries. An example of this process was the signing of the EU-US Open Skies Agreement in 2007, with further liberalising changes in 2010. This significantly liberalised air traffic between those two regions, which in turn has enabled competition authorities on both sides of the Atlantic to take a more lenient view of the British Airways, American Airways close alliance within oneworld. However, there is no global liberalised air services market. Consequently, EU air carriers operate in a liberalised domestic market, but may face restrictions to their operations to third countries, whilst they enjoy some protection within the EU from non-EU based carriers. A final regulatory point to mention is that EU competition law now applies to the air transport sector in the same way as other sectors, which was not always the case. Some of the older case law has to be understood in that context. So we have looked at the economic and regulatory background to the aviation industry and seen how airlines face significant competition within the EU that has put pressure on their margins. With that background, I now want to talk about the particular competition law questions that have arisen in the aviation industry. Starting with restrictive agreements and Article 101 of the Treaty on the Functioning of the European Union. There are two principal areas where the prohibition on restrictive agreements and concerted practices has applied to the aviation industry: cartels and alliances. In some instances, these areas have overlapped. There have been two particularly notable airline cartel cases in the last 10 years. In 2006, the Office of Fair Trading in the UK began an investigation into passenger fuel surcharge price fixing involving British Airways and Virgin Atlantic. The case began with a leniency application by Virgin Atlantic and proceeded with dawn raids at BA. Through an early settlement, BA agreed to pay a fine initially set at £121.5 million. The Office of Fair Trading brought criminal proceedings against 4 BA executives, alleging infringement of the criminal cartel provisions of the Enterprise Act 2002. The trial opened in London in April 2010, but it soon emerged that a large volume of emails that were potentially relevant to the defence had not been disclosed to the defence, prejudicing a fair trial. The Office of Fair Trading offered no evidence at the trial, and the trial collapsed. The OFT continued to investigate the civil case, and the initial fine on BA was later reduced to £58.5 million. The second cartel case was as follows. In 2007, the European Commission, following a leniency application from Lufthansa and Swiss, conducted coordinated raids on numerous airlines on suspicion of fixing fuel surcharge levels for air freight. This was part of a worldwide investigation. In 2010, the the European Commission imposed fines totalling almost €800 million on 11 carriers and dismissed the case against 11 other carriers for lack of evidence. The fine on Lufthansa and Swiss was reduced to zero for being the first applicant in the leniency process. It is notable that 8 out of the 11 carriers fined were not even based in the EU. The highest fine was on Air France-KLM at €310 million, to date one of the largest individual company fines to be levied for cartel activity in the EU. Follow-on damages cases are continuing. The Commission has also investigated price fixing of passenger fuel surcharges, but administratively closed the case at the end of 2011. Turning now to alliances. The European Commission has developed a considerable practice in evaluating these both under the previous notification regime of Regulation 17 of 1962 and since modernisation under Regulation 1 of 2003. It is worth recalling the commercial and regulatory motives for entering into an alliance. Firstly, it enables each participating carrier to offer more services without undertaking the investment of entering new routes. And secondly, a genuine transatlantic merger as opposed to an investment stake is not possible because of the restrictive ownership and control rules on both sides of the Atlantic. The Commission is generally positive about the pro-competitive effects of alliances, but nonetheless it will examine proposed alliances very carefully. One notable early alliance case concerns the notification in 1999 by SAS and Maersk of a cooperation agreement principally about code share agreements and cooperation in periods of high demand. The Commission received a complaint from Sun Air that a consequence of the proposed code share was an agreed withdrawal by each carrier from 2 routes they operated in competition, leaving only one carrier to operate it. The Commission considered this to be market partitioning and fined the parties. This was an interesting case where a proposed alliance between carriers turned out to be a cartel. The Commission has also examined the tie-up between American Airlines, Iberia and British Airways as a cooperative arrangement under Article 101. This was found to be compatible with Article 101, subject to legally binding commitments pursuant to Article 9 of Regulation 1/2003. These commitments provided for slot divestment at London Heathrow or London Gatwick, as well as New York's JFK Airport, fare combinability agreements, special prorate agreements, and access to competitors to the parties' frequent flyer programs in certain circumstances. Since December 2012, the Commission has also been consulting on commitments offered by Continental, United Airlines, Lufthansa and Air Canada in relation to their proposed alliance, in particular in relation to the Frankfurt-New York route. The Commission is currently investigating cooperation agreements in the form of code shares between Lufthansa and Turkish Airlines and the transatlantic joint venture between Air France-KLM, Alitalia and Delta Airlines. I now turn to Article 102 and abuse of dominant position cases. I want to start by commenting on market definition in air transport markets and dominance. Product markets for passenger air transport are generally defined on the basis of a route described as an origin-destination pair. Essentially, and at its narrowest, each origin-destination pair will be a separate market. The Commission will start with a narrow geographic market definition, focusing on the focal airports at either end of the route, and then consider whether other airports at either end could be substituted. The Commission will also assess the possibility for substitution from other forms of transport such as road or rail. The Commission might also consider whether it is useful to distinguish between time-sensitive or largely business travellers and non-time-sensitive or predominantly leisure travellers. Markets for air cargo tend to be defined on a much broader basis, sometimes continent-wide. Now, it is a curious feature of passenger air transport that airlines will often have a portfolio of routes, some of which are profitable, some of which make a contribution to fixed operating costs, and some of which are loss-making, perhaps because they have not been in operation long enough to turn a profit. Particularly where competition is intense, airlines may struggle to make a profit. At the same time, many routes are operated by only one carrier, and for various reasons may face few constraints from the prospect of new entry. Such a carrier will obviously be dominant on any such route markets. This may be so regardless of the overall size of that market or the size of the carrier. So a small carrier that is dwarfed by other carriers elsewhere on its network may nonetheless be dominant on a small route which it monopolises. This has interesting consequences, as one recent case in the UK highlighted clearly. In 2009, the UK Office of Fair Trading began an investigation into allegations that Flybe abused a dominant position through predatory pricing against its competitor Air South West. Air South West was a small airline that operated as a monopoly a triangular route between London Gatwick, Newquay in Cornwall, and Plymouth. Flybe began operating the London Gatwick to Newquay route in competition and offering low fares. Air South West complained that Flybe entered the route with below-cost fares, and the intent to exclude Air South West from its most profitable route endangered the airline and with it its base at Plymouth Airport. The OFT found that Flybe was dominant on two small-scale markets between its Exeter headquarters and Jersey and Guernsey. The OFT investigated whether Flybe could strengthen its dominance of these two markets by excluding Air South West from its most profitable route, undermining both the airline and Plymouth Airport, and causing passengers at Plymouth to divert to Flybe's base at Exeter. In the end, the OFT concluded that the relationship between the two markets dominated by Flybe and the focal market was not close enough to support its theory of harm, and that the losses which Flybe was incurring on its new route were consistent with start-up losses on other routes. Now, the case is interesting for several reasons. Firstly, airline predatory pricing cases are rare, particularly in Europe. The Bundeskartellamt in Germany investigated Lufthansa over allegations of predating against its competitor Germania, and the Office of Fair Trading investigated inconclusively allegations that British Airways had predated on the London to Edinburgh route, but neither of these cases formed a useful precedent for this case. Now, the standard form of predation case has involved a network carrier predating against a low-cost carrier. This was the reverse. Flybe has a more low-cost model as compared to Air South West. More importantly, airline predation cases normally involve an incumbent carrier predating against a new entrant. The theory goes that the incumbent is protecting its position in the market by seeking to exclude or discipline a new entrant. In this case, Flybe was a new entrant on the route against a monopolist. The threshold of liability was low. It was enough in principle for Flybe to be dominant in two very small markets from Exeter Airport. The OFT failed to establish infringement, in part because the evidence connecting the market on which the alleged abuse took place and the markets which were dominated was not strong enough. The result of the case in principle is that an airline can infringe Article 102 by predatory pricing where it is a new entrant on the route and where it is dominant on a related market which does not even have to be significant in scale. Since many airlines, in order to be profitable, are likely to be dominant on at least one route market, and since airlines are likely to lose money in the early stages of operating many routes, many airlines could be accused of predatory pricing. But in practice, the barriers to bring a successful predation case against an airline appear still to be high. Other possible abuses include refusal to interline and abusive rebates. In a very old case involving British Midland and Aer Lingus, the Commission confirmed that refusal to interline was not normal commercial practice and could be a selective and exclusionary abuse restricting the development of competition. In the leading case of British Airways, the Commission found that the airline's bonus schemes for travel agents were illegal exclusionary rebates which had a loyalty-inducing effect. BA was found to be a dominant buyer of travel agent services. The Court of Justice stated that a system of discounts or bonuses which constituted neither quantity discounts nor bonuses nor fidelity discounts or bonuses could be abusive if it was capable of making market entry very difficult or impossible for competitors, and if it made it more difficult or impossible for co-contractors to choose between different sources of supply or commercial partners. The court also found that the scheme was not economically justified. Abuse cases can also be found in the airport sector. These relate principally to airport charges for access to infrastructure. Often, the question concerns discrimination between national and international routes. In the early case of Brussels-Zaventem in 1995, the Commission found that the threshold of monthly fees needed by an airline to obtain the highest level of discount was so high that only a carrier based at Brussels Airport could benefit from the discount, placing other community carriers at a competitive disadvantage. In the 1999 Finnish Airports case, the Commission found that the Finnish airports operator had abused its dominant position in awarding a 60% discount on landing fees at various Finnish airports for domestic flights, but not for intra-community flights. In so doing, they gave domestic flights favourable treatment. Similar cases have been decided in relation to Portuguese, Spanish and Italian airports. In 2011, the Airport Charges Directive came into effect, a form of ex-ante regulation requiring, amongst other things, the setting of airport charges on a non-discriminatory basis. I turn now to the application of the merger control rules to airline mergers. There are several features that have emerged from these cases. Firstly, the prevalence of the origin and destination method for defining markets, despite arguments that the Commission should also consider network-based competition between the large airline groups and alliances. Secondly, the use of a range of methods for the geographic allocation of turnover. Thirdly, airport congestion raising the barriers to entry for new competition. Fourthly, the prevalence of slot divestment remedies to facilitate new entry. And finally, a package of other remedies to facilitate market entry, including interlining, access to the merged carriers frequent flyer programme, and so on. These features have evolved from the case law. I want to mention 4 cases in particular. In Ryanair Aer Lingus 1 in 2007, the Commission issued its first prohibition of an airline merger under the EU merger regulation. The Commission found that the merger would have combined the 2 leading airlines operating from Ireland and would have created a monopoly or a dominant position on 35 routes operated by both parties. The Commission considered that the remedies which Ryanair offered were insufficient to remove the competition concerns. In Olympic and Aegean in 2011, the Commission issued its second prohibition decision under the EU merger regulation of an airline merger. The Commission found that the merger would have resulted in a quasi-monopoly on the Greek air transport market. Together, the 2 carriers controlled more than 90% of the Greek domestic air transport market, with no realistic prospect that a new airline of sufficient size would enter the routes to constrain the merged entities' pricing. Again, the remedies were inadequate. Although the parties offered to divest take-off and landing slots at Greek airports, these airports do not suffer from congestion, and so of themselves, these remedies would not resolve the competition problem. In 2012, the Commission cleared with commitments in the first phase the acquisition by IAG of BMI. This case is currently subject to appeal brought by Virgin Atlantic. The clearance was conditional on the release of 14 daily slot pairs at Heathrow Airport to facilitate new entry, and on IAG's commitment to carry connecting passengers to feed the long-haul flights of competing airlines at Heathrow. Virgin Atlantic has lodged an appeal to the General Court against this clearance decision. However, and encouraged by the Commission's clearance in IAG BMI, Ryanair in 2012 began a third attempt to acquire Aer Lingus, the second attempt having been withdrawn early in the Commission's procedure. In this case, the Commission identified concerns on 46 routes to and from Ireland, an increase from 27. Ryanair proposed significant remedies, including 2 upfront buyers, British Airways and Flybe. As at the date of recording this video, the Commission has indicated that it will block this merger. Finally, and briefly, I would like to turn to the question of state aid in the aviation sector. State aid has been relevant in the following areas. First, aid to airlines in difficulty. Second, aid for the development of airport infrastructure. And thirdly, aid for start-up routes from regional airports. The Commission has issued 2 sets of guidelines in this area. The first guidelines, in 1994, cover the general principles of aid to airlines in difficulty. The focus of the 2005 guidelines has been on aid for the development of airport infrastructure and start-up aid from regional airports. These latter guidelines followed the Commission's investigation into Ryanair obtaining low charges for starting routes from Brussels-Charleroi Airport. Although the Ryanair-Charleroi decision was overturned by the General Court in 2008 because the Commission had misinterpreted the private investor principle, the Commission has continued to investigate start-up aid on the basis of the 2005 guidelines. The Commission has announced that in 2013 it will issue new guidelines to replace the 2005 ones. Finally, I'd like to draw some conclusions from this brief survey. The aviation sector is an active one for the application of competition law. For me, 3 things stand out. Firstly, the high capital, low margin nature of the airline industry is very significant for the levying of fines for antitrust infringements. Fines are calculated on the basis of turnover, which in airlines tends to be high. However, since profits are often low, a significant fine, together with provision for follow-on damages or settlements, could wipe out a year's profit or more. Secondly, there is a low threshold at which an airline can be found to be dominant, based on the existing methodology of defining markets based on origin to destination pairs. Finally, the drive towards greater efficiencies encourages airlines to consider merging where possible or entry into alliances if not, all of which gives rise to interesting questions of competition law and practice. I hope you've enjoyed this brief introduction to competition law in the aviation industry. Have a safe flight, and bye for now.